number 82, Police Benevolent Association versus City of New York. Counsel?
Thank you, Your Honor. Tony Coles, along with Steve Engel for the appellants. And may it please the court, I'd like to reserve 2 minutes for rebuttal.
Yes.
Under the diaphragm provision of Section 1081, it is legal for an officer to sit, kneel, or stand on the torso of a suspect while effectuating an arrest, even if that impairs breathing, unless the suspect's diaphragm is compressed. But the major, huge flaw in the statute is there is no way that an officer can determine whether or not a suspect's diaphragm is being compressed, much less a prosecutor weeks or months later, or another officer on the scene with a duty to intervene.
So let's say the encounter is not fatal, but there's the activity you describe, forget the diaphragm, but the activity you describe. How does a prosecutor prove that?
I don't think a prosecutor can prove that because the ultimate knowability of whether or not the diaphragm can be compressed is not something that you actually can tell.
So isn't that a proof issue and not a vagueness
No,
issue?
it's actually a very core due process issue for cops, for police officers, because it does not tell them when what is lawful conduct in effectuating an arrest crosses a line from enforcing the law, protecting the public.
What about the fact that officers are trained about the existence of diaphragms, where they're located, how they work?
Sure.
Doesn't that provide them with the requisite knowledge that what they're doing could involve compression of the diaphragm?
Well, could involve compression of the diaphragm is not the standard in the statute. Knowing the anatomy of where the diaphragm is does not tell you whether or not the diaphragm is being compressed.
Well, let me ask if you're sort of reading the words in the manner that out of the statute. That is, the statute could have been written to say, sitting, kneeling, or standing, compresses the diaphragm by sitting, kneeling, or standing, but it doesn't say that. It says, sitting, kneeling, or standing on the chest in a manner that compresses the diaphragm. So there's a way to read it, I think, that talks about the manner rather than the effect.
There is no way of determining the consequence to the diaphragm.
No, I know.
From
That's
a police
actually,
officer.
that's sort of asking what, in a particular case, happens to the diaphragm. But there's a way to read it as outlawing certain manners of sitting, kneeling, or standing that have the tendency to compress the diaphragm, regardless of whether they do in a particular case or not.
Right, but the basic phrase, compressing the diaphragm, is still not something that's knowable.
That's true, but but ways that manners to compress the diaphragm might be knowable. That is, you could say, here are the following ways of sitting or standing or kneeling at someone that are likely to compress the diaphragm, and that would be things that are in the manner of compressing the diaphragm, whether it's actually compressed or not.
Well, that doesn't give any notice to an officer as to when the diaphragm might in fact be compressed. And it's the compression of the diaphragm that leads to the impairment of breathing that in theory creates the crime.
Well,
So the diaphragm itself, according to the unrebutted record before the trial court, is something that is not normally a compressible muscle. It is below the rib cage. It is below the liver.
Is there a way to restrict the flow of air or blood by, I'm sorry, let me just get the language exactly as it is, by sitting, kneeling, or standing on the chest or back, which is unrelated to the diaphragm?
Absolutely.
Okay.
And Dr. Lettieri addresses that in the record. And that's part of the problems over here, is you can actually squeeze the chest and compress the chest, and that will make it difficult to breathe. You can squeeze the lungs, and that will make it difficult to breathe. A suspect may actually be out of breath, and that would make it difficult to breathe.
But then, if that is the case, would you not know then, if you're not doing it that way, right, in ways that are not about the diaphragm, that the other ways are about the diaphragm. That is by process of elimination that an officer would understand.
Well, they may or may not be above the diaphragm because you can't actually touch the diaphragm. In other words, the diaphragm is protected by the rib cage. It is within the thoracic
I'm not
cavity.
sure that I'm reading the statute the same way you do. There are two clauses that begin in a manner and in a manner, and I would read those as parallel. And the restricts the flow of air is in the first in a manner, and the second in a manner doesn't have anything about the restriction of the airflow. It just says what's prohibited is restraining an individual by sitting, kneeling, or standing on the chest or back in a manner that compresses the diaphragm. That's it. There's nothing about airflow there.
Right, but it has to be something that will result in compressing the diaphragm.
Can I just confirm that is your reading, because that was not my reading? So I just want to know what you are saying is the correct reading of this statute.
My view of the correct reading of the statute is that the statute requires proof that the diaphragm was compressed, and that is an unknowable event.
No,
for a
I'm
police
asking about
officer.
this first part. No person shall restrain an individual, and then it says, in a manner that restricts the flow of air or blood. Do you think that part, in a manner that restricts, only applies to the chokehold, or applies to both the chokehold and the diaphragm compression?
I think that applies to both, Your Honor.
Okay.
I think that applies
It's not the
to
word compress.
both provisions.
You don't have an issue with the word compress. It's the phrase compress the diaphragm, right? Because
Yeah, yeah,
compress is in the chokehold ban.
Yeah, that's actually a great question. This is, the issue in this case is not what does compress mean or what does diaphragm mean. It means, is it knowable for an officer effectuating an arrest to know when the diaphragm is being compressed? And the answer to that, unrebutted in the record, is he can't.
So,
You can't
counsel-
see the diaphragm.
It seems to me this is a little bit of an unusual vagueness challenge, because a lot of times I think statutes that are declared void for vagueness have a particularly subjective standard, like annoying, for example. What's the best case for you, would you say, that involves what I take it to be, it's sort of a scientifically unknowable fact and therefore unduly vague?
Oh, I think that the core standard that we have in People versus Burke is the statute has to give fair notice to a police officer when he actually is committing a crime. And since it is unknowable when you're making an arrest as to when the diaphragm is compressed, the statute itself is void for vagueness. And you know,
So it's not enough to be clear that you're directed not to engage in certain conduct in those areas. You have to actually know that the scientific application of what happens to the diaphragm.
I'm glad you asked that question, because both the appellate division and the city try to rewrite the statute. They actually, in a way, throw in the towel in trying to explain how you can know when the diaphragm is compressed. You know, the city below said, well, you just don't have to, you just avoid sitting, kneeling, or standing on the suspect. Well, that's not what the statute says. That's a different statute.
Yeah, but I don't think, unless I've misunderstood the Chief Judge's question, I'm not sure you've answered his question, which his question was, regardless of whether or not there's an actual compression of the diaphragm, is the prohibition on doing something based on what is already described as sitting, kneeling, or standing on the chest or back, that would, under perhaps normal circumstances, compress the diaphragm, whether you do or don't?
No, my view of the statute is you actually have to compress the diaphragm in order to violate the statute. I think that is clear. Now, just what the appellate division said. The appellate division said, well, we don't really know how you can compress the diaphragm, so we're going to rewrite the statute to talk about putting pressure in the vicinity of the diaphragm. The vicinity, that could be between the hip and the shoulder. It could be between the waist and the knee. And it doesn't shed light on the core question of how do you know that the diaphragm is compressed when you can't see it, when its normal operation actually doesn't involve compression. Its normal operation is to flatten and then expand. And the statute does not actually say it's illegal to interfere with the operation of the diaphragm.
Let me
It
ask you
says
this,
it's illegal to compress.
is there, within the medical community, an understanding of what would be the kind of action, the manner that would compress a diaphragm? That's, you're saying that's completely unknowable?
So
Putting aside whether, in actuality, the diaphragm is compressed.
It is actually a terrific question, and the evidence unrebutted before the trial court is that a police officer cannot tell when the diaphragm is being compressed. You can tell, unless he had a fluoroscope or X-ray vision, that there is no external way, like if you're pressing on the neck.
What if you're kneeling in an area you know the diaphragm to be, generally, and the person is having trouble breathing? Doesn't that give you some indication you might be compressing the diaphragm in a manner that restricts airflow?
Well, the evidence below is that doesn't necessarily mean, that compressing the diaphragm doesn't mean that you're interfering with the operation of the
Granted, you
diaphragm.
may not be.
No, but that's the only way you violate the statute. If you agree with the chief judge's interpretation of the provision, it has to be in a way that restricts airflow.
No, other way around.
No,
I think the
it-
airflow only applies to the chokehold.
Yeah, I'm the one who thinks
Then I
that.
agree with Judge
Yeah.
Rivera.
Okay. No, but I actually want to go back to that because the appellate division talked about that a little bit as well. And I think what the appellate division said is an indication that the statute is void. The appellate division said, well, sometimes you have to make a reasonable estimation. But the evidence in this case doesn't support that. And a reasonable estimation of pressure in the vicinity of the diaphragm is such loose language that it simply doesn't
But
give fair
isn't the
notice.
intent of this provision to prevent the unfortunate death from asphyxiation? I mean, the whole point is to avoid the terrible, horrible outcomes that were going on at the time that continue to go on. So isn't it obvious then that it's not about compressing the diaphragm in sort of the abstract, it's the consequence of that.
So, and absolutely, everyone sees the need and the reason for that statute, but this statute actually doesn't accomplish that.
What could have saved it?
I don't know that anything, I don't know that anything could save this particular statute.
Well, I thought you were saying, maybe I misunderstood, that if you struck the words in a manner that compresses the diaphragm, the statute would be valid.
Yeah, but you would rewrite the statute.
Right.
Yes. I guess what I was suggesting before is that the city council needs to revisit this.
No, but
This
my
whole thi-
question was, if they're trying to achieve the goal, as I think you set up before, which is not to prohibit sitting, kneeling, or standing on the chest or back when attempting or effectuating an arrest, they're not completely barring that kind of action, then what would save this statute?
Okay, well, they're not even borrowing it if you impair breathing. It's only in the very limited circumstance that you compress the diaphragm. I don't think there's anything that would save this statute the way it's written now. The city below, tried to save it by saying that it should be limited or it should be rewritten to preventing or prohibiting police officers from kneeling, sitting, or standing on the torso of a suspect.
Full stop.
Period.
What if they
Period.
define diaphragm and/or compression?
I'm sorry?
What if they defined diaphragm and/or compression?
Well, they actually haven't, and then
But
the way-
I'm saying, and let's say we agreed with you,
Yeah.
but they still were concerned about the consequences, fatal consequences of the action, they are trying to do something about it.
Yeah, I think the evidence in this case indicates that regulating around what happens to the diaphragm is not a comprehensible way of dealing with an impairment of breathing.
Okay, thank you. You have your rebuttal.
Okay. Thank you very much, Your Honors. Appreciate it.
May it please the court, Stephen Engel, on behalf of the Patrol Officers Benevolent Association of the City of New York. I'd like to reserve 2 minutes of my time.
Yes.
I think what the court has been wrestling here is the fundamental indeterminacy of this phrase, compresses the diaphragm. There's no question that there's a legitimate interest that the state of New York and the state legislature was focused on in the wake of George Floyd's death, and the city of New York was focused on the very same thing at the very same time.
Counsel, what I'm struggling with is my inability to differentiate between compressing the carotid artery and windpipe with compressing the diaphragm. I don't see a meaningful difference there. So if you could educate me about that, it
Sure.
would be great.
The difference is that the windpipe is right here. The diaphragm is a muscle that goes around the back of your spine. It is not, if you said pressing the stomach, compressing the stomach, that makes sense. Compressing the chest makes sense. But that's not what this law says.
You know that thing you just did with the windpipe? I didn't know that. I'm not joking. I really didn't know that that's where the windpipe is. But
You could be
you
trained.
say that's legal.
You could be trained at compressing a carotid artery or compressing a windpipe. It's right underneath the skin, and the law would be focused upon where there's direct pressure applied. The problem here is that compress the diaphragm, as the uncontradicted summary judgment record reflected below, with 2 medical experts, 2 police experts, it's an incomprehensible subject.
So what about the police department's internal instructions to officers about how to avoid compressing the diaphragm? Basically turn the person over, that sort of thing.
Yes. So the traditional advice has focused upon, where feasible, not sitting or standing, and as soon as practicable, turning the arrestee over, recognizing the risk of positional asphyxia. But the NYPD has never had a categorical rule that an officer has violated the policy if, in the course of a struggle, she's wrestling with the detainee and there's some pressure of a knee or otherwise placed upon the detainee. The goal is a safe, lawful arrest.
Well, you would have a justification defense in the circumstance you're describing, right?
No question that their justification defense would apply. At the same time, a police officer dealing with this dangerous situation is entitled to fair notice of the prohibition, and the city chose a phrase that's fundamentally indeterminate.
And is that because you think the diaphragm is too big, or because they can't know where it is, or they can't know when it's compressed?
So, as Dr. Oppenheimer said, it's not a compressible muscle. It's just not, it's not something that one compresses. The diaphragm goes, in and out itself in the back, in running around into the back. But what they're trying to get at here, they're getting at interference with breathing, right? That's what they're concerned about. But compress the you can interfere with breathing without putting pressure on the diaphragm.
So is the problem that there's a lack of precision, physiological precision to the language with respect to the diaphragm?
Yes, there's a problem that it is medically, scientifically, plain language meaningless, and this is a criminal statute directed at officers. There is not a mens rea requirement.
So-
there is not an injury requirement as well.
Is it incomprehensible, as in I can't understand it, or is it medically impossible, as in you can't physically do it because that muscle can't be compressed?
An officer cannot know whether or when he or she is violating this
No,
statute.
but you said a
compressing
moment
it.
ago that the diaphragm cannot be compressed. You've made it sound almost as if there's no way to violate this provision.
If someone's diaphragm were removed from the body and placed upon this table, one could compress the diaphragm. But in the course of the body, it's protected in the rib cage. The rib cage surrounds it. It is not lying just against the skin, and it's very difficult to put.
So why isn't the
specific-
answer then not that it's vague, but that it can't be, to Judge Canatera's point, it can't be violated?
Well, I think the problem is that there's just no, it may have difficulty, the DA may have difficulty bringing a prosecution, but as to the officer who's being asked in the course of a struggle whether or when it's violated, that's a problem. There is no fair notice in there. And, the precedents, and you asked, Judge, about what cases, are we talking about? I read the vagueness cases, starting with Colati at the U.S. Supreme Court, also Golb and New York Trap Rock, to say that you cannot have a prohibition on actions that the person taking those actions doesn't depend on the unknowable effects upon a third party, whether it's the third party's body in this case, or whether someone is annoyed, or whether someone can hear noise.
Let me ask you this. So, following up on these questions, if you can't compress, it's a muscle that cannot be compressed, what can be done to the diaphragm?
Well, again, I don't think that actually, given that it's within the rib cage and that it's kind of internal in the body, it's very difficult
It's completely
to affect.
encased, is your point. It's completely encased.
It is completely encased, and therefore, if the city or the state wanted to focus on the risks of interfering with someone's breathing, a statute that focused upon whether or not someone could breathe, whether there's a knowledge requirement, whether there's an injury requirement
So when
would
someone
be...
puts their knee on your chest, what is interfering with the breathing? If it's not, I get your
I
point.
mean-
You're saying it's not because you're putting pressure on the diaphragm. What, because you're not on the windpipe, then what is it?
I mean, again, I'm not a medical expert, but what you're talking about is you are interfering with the ability of
Yeah.
someone to breathe. It is interfering with the entire breathing system.
And you're saying
And
that's unrelated to pressure on a diaphragm?
Well, it may or may not involve pressure on the, I mean, it's not literally pressure on the diaphragm. It is interfering with the diaphragm's ability to power the respiratory system. But that, of course, is not the standard. That's not what's in this statute. And, and if it was a situation in which an officer knows that he or
So
she is interfering with breathing, it'd be a big
I'm
question.
sorry.
No, oh, I'm sorry.
If they wrote, which otherwise interferes with the diaphragm, would that have worked as opposed to compression? If you're saying compression is not something that can be
I would
done
say
to
if
a
an
diaphragm.
officer knows that they are interfering with the operation of someone's breathing or with the operation of someone's diaphragm, that would be a better statute. That, we may not be here on vagueness. and-
How would they know that? If you're saying they can't know what compression is, but you're really saying you can't compress a diaphragm.
Well, compression doesn't make any sense. The diaphragm is not being compressed here. And if I may say a word on preemption, which, I think there's been a lot of talk, starting with Justice Love on the vagueness issue. But this is the only case that I'm aware of in which a municipality revisited the judgment of a state only 1 week after. And there's no other precedence here. I mean,
Well, they've been working on this long before, right?
well, both the legislature and the city had been working
Yeah,
on
but
this.
I'm quibling with the word revisit, I guess.
But literally, in the wake of George Floyd,
Yeah.
the state legislature, and the legislative history is completely clear here, was focused on the problems with Eric Garner, with George Floyd, with the risks of asphyxia in connection with an arrest. And they went back and forth and came up with a statute that addressed intentional obstructions of airflow that result in serious injury. That's the Eric Garner Act at the state. The city essentially revisited that judgment
Well,
and made a different
They were
decision.
both visiting the judgment at the same time, and they, unless you're arguing that they didn't have the ability to do that, I'm not sure where your argument is.
Well, I think I am arguing that where the state has pervasively regulated the issue of law enforcement arrests.
That doesn't
and
matter.
where they-
That doesn't make a difference who came first.
Well, it doesn't necessarily, but typically when we're dealing with preemption cases, we are wondering what is the state's intent, either explicitly or implicitly, and is the city filling the gaps? Are they going orthogonal to something that the state was thinking about? Most of these cases happen several years later, and then the question is the law that the legislature put on the books, does that have a preemptive effect on what the municipality is seeking to do? But here, we're in a situation and where this is literally the same issue at the same time, and the city is doing a
Can I
very
ask-
different judgment.
What is the exact field that you're saying is preempted? Lawful arrests or arrests and breathing? What's the exact field?
At a minimum, I would say the risks of asphyxia in connection with breathing, but there is a pervasive web of state laws regarding law enforcement arrests, both the arrest authority, the who, what, when, where of arrests, as well as the use of force. And there is actually no precedent for this city law.
So are you saying that the entire array of issues around arrest are now field preempted and localities can do nothing?
So I would say two things. One, I would say, on this case, all that is necessary is to say that the risks of asphyxia in connection with an arrest was specifically addressed by the
That's a
legislature.
very narrow field then.
I mean, that could be a narrow field. But I do think there is no other New York City law that has as a matter of criminal prohibitions, regulates arrests. And many law enforcement officers operate throughout the state, whether it's the MTA or the Port Authority or the New York State Troopers, or the like. And so it does make sense that this would be regulated on a statewide basis, and this wouldn't be limited to just municipality by municipality. Some of Mr. Cole's clients are from adjoining counties who are now afraid to send their law enforcement officers into the city because of the risk of this law. And so I think there's a narrow basis for field preemption here. I think you could also describe it as conflict preemption. But the reality of the situation here is that there is a real field of arrests in which the Criminal Procedure Code does the circumstances of arrests. It also addresses the use of force. There is the justification defense, which is a state defense, and then there's specifically the general penal code in this area. And so, the idea that the city, talking about the very same issues at the very same time, reached a very different judgment from the state, which was much more balanced if you look at the legislative history, which, we
So
cite.
what rights do municipalities have with respect to their own enactments?
Well, I think specifically with respect to the risks of asphyxia, I don't think they have that right. Clearly,
In
the city.
any other areas that affect the penal law, do they have rights?
Well, the local penal laws, sure. That's not covered. But traditionally, what New York City has done.
So put the city council aside. Could the police department, as a matter of internal policy, make rules preventing kneeling and standing and so on?
And they have, the police, yes is the answer. Look, the New York City as an employer
So that's
has.
Yeah, okay.
That's the distinction I would draw, Your Honor. New York City as an employer has an array of laws and procedures, some of which are in the code itself, which govern the conduct of officers on the job. There's no question about that. What's new here is a criminal law directed at police officers in an area that has traditionally been regulated by the state, and not even traditionally, but in this specific instance, this very issue was addressed by the state. So that, by the state. So that's, I think that there has never been another case in which the state and the municipality were addressing the issue at the same time. And, and I would just point out that the Lansdowne Entertainment I was looking at this court's precedents on preemption. This was a case about closing times for nightclubs. And in Lansdowne Entertainment, the city said, we want the Limelight Club to close at 4, and the state had a law that said, the alcohol beverages control law said you can be open till 4:30. Now, you could comply with both of those laws just by closing at 4 o'clock. This court said, no, this is preempted. The city cannot add on additional layers of an issue that the state has expressly addressed. And similarly, that's what we're dealing with here.
Thank you.
Thank you.
May it please the court, Richard Deering for the city. We'll start on vagueness. I think it's pretty simple, actually. Compresses the diaphragm. Don't compress the diaphragm means don't put pressure on the diaphragm, as many of the court's questions reflect. It's a plain.
Mathematical precision required?
Absolutely not. This court has said that multiple times, and I think that's a key point, because the premise really of most of the argument from the plaintiffs here is you have to be able to know exactly when if I move 6 inches over, I might not be in violation, but 6 inches here I am. You have to be able to make that differentiation. The cases repeatedly reject that kind of thinking. Where plaintiffs say that we and the First Department are rewriting the statute, I think they're misunderstanding what's happening. We're not rewriting
the statute, counsel. Do you read in a manner that restricts airflow to apply to kneeling, sitting, and et
I
cetera?
do read it that way, that it applies to both aspects. I would say, though, that if the court believes there's another way to construe it, and that way would save the statute, were at any risk, the court would have an obligation to do that rather than strike it down. I think the key point from the First Department and us is that as a matter of that as a practical matter, an officer can know when they're applying body weight pressure in the vicinity of the diaphragm to the exterior of the body, and know they're therefore in jeopardy of violating the statute. There's a number of DWI cases from all across the country that make this exact point. A lot of people don't know when they're over the limit. Some states, the limit doesn't even apply until hours after you drive, and the courts have consistently rejected the idea that makes the statutes vague. The same is true of noise statutes.
Why not just have written, put pressure on the diaphragm? I don't know that would have kept them at bay, but nevertheless.
I would suspect not, but I do think that's in substance what the statute says. Don't compress the diaphragm means don't put pressure on the diaphragm. And if you want to see what that looks like, there's a video from Commissioner Bratton, who really inaugurated the PD's policies in this area. There's a pictorial representation of what happens inside the body when pressure is put.
Well, here's my problem. Aren't we on this kind of challenge just limited to the four corners of
I don't think so, because we're here to,
language chosen? We can't look to somehow import definitions or understandings?
no, I don't think, we're talking about an exercise in construction. The meaning comes from the dictionary, I think. Compress means put pressure on diaphragm, we know what that means. You put them together, we understand what that is. I'm saying, if you want to see what it looks like, because we've heard some things about its supposed impossibility, which I do think would be an argument that goes more to the question whether it can be violated than whether it's vague. But the Bratton video shows you, and I'll tell what the medical examiner says this, describes this, and you will see a illustration that shows it happening. When pressure is put on the back in the abdomen area, raises the abdominal contents, pushes up into the diaphragm and makes it more difficult for the diaphragm to contract. And there's a pictorial representation of how that happens. We cited 2 cases, page 478 of the record, where courts described that exact phenomenon themselves. You pinned a person down, the officers did, caused his abdomen to be pushed into his upper chest and interfered with the movement of the diaphragm. Another case, his diaphragm can't move because his abdomen is on the bed being pinned down. So we have cases in this record that describe that. We have the Bratton video that demonstrates it and shows a picture of it. I think we know exactly what it looks like when this statute is violated.
Counsel, based on your answer to Judge Garcia's question about how you read the various clauses, specifically your answer with respect to restricting blood and air, if there were a problem with the so as to compress the diaphragm section, a vagueness issue with that, I imagine that means you could excise that section from the statute and still have the sitting, kneeling, standing provision survive. Is that
I think you could do
correct?
that. You could alternatively construe the phrase compresses the diaphragm if you thought it would benefit from construction. There are many options available to you. I think the thing that is absolutely not established here is that the plaintiffs have overcome the strong presumption of validity in a
So
local
what's the
enactment.
line, though, between construing it so that it has some clear meaning and remedying or rewriting a vague statute?
I mean, I have 2 responses to that. I think the first is you can engage in an exercise of construction like any other exercise of construction. I would submit the exercise, which you do with many criminal statutes. We have a number of cases from this court where this court has done precisely that, sometimes over dissents. I mean, there are meaty construction issues around criminal statutes. We can engage in that exercise. I actually think it's a pretty short exercise because we're relying on the ordinary meaning, dictionary meaning of these words, which is pretty straightforward. There is a second layer, which is if the court believes the statute is in peril, I don't think this statute is in any peril under an appropriate vagueness standard once it's construed. If it is in any peril, the obligation of the court is to identify whether it is susceptible of any construction that would save it. The line, the outer line on rewriting the statute, which this court has expressed in a few different cases, is it not fairly susceptible of any construction under which it would be valid?
Short of having an encyclopedic knowledge of anatomy, what is it about that section that is susceptible to a fair construction? Is it just restricting breathing so that a person can't breathe, or is it something else?
I think the whole thing is susceptible to a fair construction, and here's what it would be. You restrict airflow. I think we have agreement that that's not vague or difficult to understand. Sitting, standing, kneeling on a back or chest, that's pretty straightforward. In a manner that compresses the diaphragm, that means in a manner that would put pressure on the diaphragm in the way that I just described. That's a very straightforward dictionary reading of the words. It's not even that hard of an exercise of construction, and it is clearly not vague. The Oppenheimer, I think the flaw in the Oppenheimer declaration, the doctor's declaration, is to treat this as if it were a medical term, but it doesn't purport to be a medical term. It is just a plain language description in a statute that's directed at police officers, not at physicians. And even in that opinion, even in that declaration.
And why use the word diaphragm? If it's geared towards a common police officer that doesn't have that anatomical encyclopedic knowledge, why not say the chest or the vicinity of the chest? It's hard to say you can use the ordinary dictionary meaning of compressed and then the ordinary meaning of diaphragm when most people don't even know where the diaphragm is.
Well, the statute also refers to the windpipe, also refers to the carotid arteries. These are not, I don't think, essentially medical terms. They're just plain language descriptions of parts of the body. The line I would draw, though, is there's a difference. These are police officers who are trained specifically on basic anatomy. They're not physicians. So what I think the daylight here is, it's not a statute that is designed to be read in a medical sense. It's not a direction to physicians the way the statute that was at issue in the Collodi case was. But it does use terms of anatomy, just like the state chokehold law uses that they don't object to, just like the portion of this law about the chokehold uses portions of the anatomy, because the statute is in part about vulnerable parts of the human anatomy that lead to serious injury or death when they're mishandled or when force is applied by police
Counsel-
officers.
Go ahead.
I'm sorry, to just explore that point a little bit, it is a statute aimed at a very particular audience, right? It's not the general public. Now, I think training for a particular police force only gets you really so far, because it applies to any, as you're, I want to say, applies to any law enforcement officer who comes in the jurisdiction, right? So it could be a trooper, it could be MTA, whoever. But how do we factor in that audience in the analysis of vagueness?
I think that it factors in favor of giving, I think, wider berth to the statute, and that's true in two ways. And the first one, which I think is most directly responsive to your question, is kind of an analogy to the doctrine you see about statutes that are directed at businesses, that says they have the opportunity to review the statute, understand what it means, and sort of develop a plan for how they comply. And the same is true in the case of police officers and police forces, and was done by the NYPD here. And I will say, it's not just the NYPD. Police forces across the country, largely as a result of Commissioner Bratton's efforts in the mid-90s, train their officers about compression asphyxia, compression restraints, et cetera, et cetera. The second way that I think it matters is because a key question in vagueness law, especially when you're looking at the possibility that someone might have to sort of give some degree of berth, around violating the statute, is whether there's the underlying conduct implicates constitutional rights, because there is particular concern in vagueness law for statutes that would chill the exercise of legitimate constitutional rights. And here we don't have that either. We don't have this conduct of police officers implicating any constitutional right other, potentially, than the victims who are being arrested, who are being injured, who are being killed by these tactics. I just would close, I would make one more point on vagueness, which is just to round out the list I tried to give about DWI, noise. We have an assault weapons statute. We have child pornography statutes. We have online gambling statutes. A variety of courts have said that the argument that I can't know precisely when I'm violating the statute, when I know that I'm in the clear zone of violating it, that does not state a valid vagueness objection. And I'm happy to answer any other questions on vagueness. If not, I just want to touch very briefly on the preemption question. This is a very simple preemption case. There are not really examples. My friends are citing cases where the state has given forms of license or permission to certain kinds of businesses, and there's a question in those kind of cases whether a locality may have latitude to vary that license, but there really aren't cases, other than one, which is quite different, where a state-level prohibition has been understood to preempt a locality.
What about their argument that because law enforcement are able to effectuate arrests across jurisdictional lines, that they need one clear standard?
I think if the legislature had said that at any point, we might be having a different conversation. But preemption isn't determined by sort of speculation in the air about why uniformity might matter. This court looks for specific evidence that the legislature has made that judgment. And the best example I could give you, and it's particularly pertinent on field preemption, or any preemption, from Garcia, the court said, it's only when the state specifically permits the conduct prohibited at the local level, or there is some other indication that deviation from state law is prohibited, that preemption occurs. And there are, the cases that plaintiffs have relied most on, cases like Con Ed, cases like DIAC, the record in those cases and the court's opinion in those cases lists numerous pieces of evidence, either from the legislature or the governor, that said we need a comprehensive state-level scheme, we need to replace an uncoordinated welter of state and local approvals with a one-stop shop at the state board for siting power plants. You see evidence of that. What you don't see is litigants coming up and saying, I think uniformity would be a good idea, and attributing that intention to the legislature and thereby displacing
Counsel-
the home rule authority.
I presume this provision would apply to all law enforcement officers in New York City, not just NYPD, right?
That is correct. That's how it's
So
written.
if a sheriff were to effect an arrest, it would apply equally to them, would it not?
That is correct.
This issue about their knowledge, the specialized audience, the training they have, do you have any concerns that maybe those other law enforcement officers are not adequately trained to understand what this statute means?
No, I don't think so, because I think the point about training is less, I think, that specific evidence of training on this statute, but just a practice of training on tactics to effect arrests safely, where there are laws that are pertinent to those tactics, to tell officers what those laws are and how to prudently avoid violating them. That is done by the PD. I'd submit it's done by police forces all over the place. And the last thing I'd say is the idea that this kind of idea that we like need a cooling off period in the city before we can act, that like if we act too close, there's an issue that's so significant and gets attention at two levels simultaneously, and that, to me, it's just made up. It's also quite counterintuitive. What we have here was the Eric Garner incident in New York City in 2014 profoundly affected the city of New York. The George Floyd incident 2020 unleashed protests, historic protests in the city of New York and other places. The record here shows dozens of people came in and testified before the city council. The communities in New York City felt deeply about what was going on and this law. The idea that there would be this idea that it's sort of too important, that if the state's looking at it now, if it's too topical, if it's too timely, the city has to take a back seat, has to chill out, has to wait, and maybe come back in 5 years. There's no law that says it. I would submit it's not consistent with the idea of home rule in New York State, and it would mean that you cut off political engagement, local engagement in the city of New York in ways that are unwarranted and undesirable.
Thank you.
Thank you, Your Honors. I just want to start quickly coming back to Justice Rivera's question, because I want to make sure that we're on the same page on that. As you asked, can you be putting pressure and interfering with breathing without putting pressure on the diaphragm or compressing the diaphragm? And the answer to that, it's in the record, and the answer is yes, you can. You can compress the lungs, you can compress the chest. As I mentioned earlier, someone might even be out of breath. There are many reasons during an arrest, particularly a resistant situation, where breathing may be impaired. The problem here is you can't tell that it has anything to do with compression of the diaphragm. And I couldn't disagree more with what my colleague said about not rewriting the statute. The statute says you go to jail for a year, potentially, if during an arrest you compress the diaphragm. And he's saying, don't worry about that. If you put pressure on the diaphragm, if you interfere with breathing. No, we're strictly construing a criminal statute. The city council chose the word compress. That word in combination with diaphragm does not give fair notice of when it happens. It is not a term in common usage. I've never seen a statute that used the word compress the diaphragm before. It's clearly a technical term.
Can we look to the dictionary?
You can look to the dictionary, but it'll give you the definition of compress and diaphragm. It doesn't tell you how to know when the diaphragm is compressed. So looking to the dictionary doesn't solve the problem. And the idea that you could actually sort of change the statute in these sort of gross ways that the city was talking about and not call that rewriting a statute makes no sense at all. They're actually rewriting what the city council said. Even the appellate division changed what the city council said, and that's because this is fundamentally just a flawed law. It needs to go back and and
What if it said in a manner that places pressure on the diaphragm? Would that have saved it?
That is a different statute. And you have to have hearings on that, and you have to figure out what pressure on the diaphragm means and what the doctors say about that. But that's not this statute. And to say that you can send someone for jail just by changing a couple of words, when the city council chose the word compress, and you can't prove that, you can't know that as a cop, that is incredibly
I thought you were going
unfair.
to answer Judge Rivera's question by saying that wouldn't improve the statute at all, because an officer can't know whether he or she is putting pressure on the diaphragm any more than they could know whether they're
I
compressing
think
it,
the
but-
city council might actually come to that conclusion.
Well, I was asking about your conclusion, actually. I think that's what Judge Rivera was asking.
Well, based on the record, not my conclusion, based on the record, an officer effectuating an arrest cannot tell what is happening with the diaphragm.
Whether it's being compressed or whether pressure is being put on it.
Yes, or whether or not it's being interfered with, the operation, which is different than compressed. If I could just make one last point, to just the Bratton video, which is a 1994 hearsay video that is really not part of the record, but even if it is, it actually makes our point. It does not explain how the diaphragm is compressed, or if the diaphragm is compressed. It specifically talks about, Dr. Hirsch talks about compressing the abdomen, which is actually something you can see. That there's no discussion in that video about compressing the diaphragm.
I got the impression from reading your adversary's brief that the bottom line of the Bratton video is don't sit, kneel, or stand on a person's chest or back.
And that's the argument that the city made to the trial court. And the trial court said, well, if that's the law that the city council wants to pass, then they can actually consider that and decide if they want to do that. It's not what the law says now. As I said at the beginning, the law allows you to sit, kneel, or stand, even impair breathing, so long as you don't compress the diaphragm. But you don't know how the diaphragm is compressed. And the last point, and I know this is in the briefs, but the people who passed this law didn't know what it meant. Chairman Richards of the Public Safety Committee said, well, we left that a little vague. The speaker at the time said it was subjective, not clear. And even the mayor at the time, Mayor de Blasio, said the diaphragm provision needs a little bit of clarification. I would ask you, if the people who wrote and passed the laws themselves don't know what it means, how can you ask a police officer in the middle of an arrest situation to figure it out himself?
Thank you.
Thank you very much, Your Honors.
Thank you, Your Honor. Picking up from that, I heard my friend say that this is like an economic regulation, and that because it focuses on a potentially trained office at the NYPD, putting aside that other law enforcement officers may not be trained with the NYPD, we can tolerate a certain degree of ambiguity. That really puts the presumption on its head. I mean, in other areas of the law, like the Fourth Amendment and the like, the U.S. Supreme Court has been crystal clear, cases like Graham versus Connor and the like, that we're depending upon officers to make split-second judgments in dangerous situations. And the law doesn't impose a higher standard on temporary misjudgments or the like. It actually, it needs to take into account reasonableness. And of course, that's the same thing that the justification defense under Penal Law 3530 says.
Can you rely on dictionaries?
Can you rely on dictionaries? Of course.
Sure.
Of course you can.
So if there's a definition for compress, can you just swap it?
Well, I think that
Will that resolve the problem?
No, Your Honor, because compress the diaphragm is just not a phrase that an officer can know whether or not he or she is complying with.
How does that uncertainty lead to arbitrary enforcement? Because it seems pretty clear to me what you can and cannot do.
See, I think it leads exactly to arbitrary enforcement, precisely because people kind of know what we're getting at, but many people may violate the law, but they're not the ones we're getting at. You have a situation in which the prosecutors are going to pick their targets, and there is going to be a diaphragm cop someday, if this court doesn't act, who is charged with this, and many other people are not. And that's why we want clear laws, because we want neutral administration of the law. And if there is a prohibition, it applies to everyone, not just some people.
Is that what happened when it was a prohibition in the employment that the city prohibited it
Well,
in the employment relationship without the law.
Well-
And sometimes it was enforced, but some argue there were no real penalties.
no, I think what happened is that the penalties were penalties for assault, penalties in, extreme cases for manslaughter and the like. There were criminal laws that regulated unreasonable force. And what the policies were, and this is in the Bratton video, this is, elsewhere, the policies were, don't do it where possible, where practicable. I mean, this is, I haven't seen the Bratton video myself. It appears for the first time in their brief, but even reading what they said, it says, turn people over onto their side as soon as possible. So there is an understanding there that it's not a black and white law where you've actually violated a criminal law in this context. It's a situation which officers are entitled to make reasonable judgments, and where there are extreme cases, there are laws on the books, and obviously there is discipline as well at the NYPD, but there are laws for those cases in which the officers go beyond, the few cases, but the cases where they go beyond, there is assault, there is manslaughter, and there are other state penal laws, including aggravated strangulation, which, just on the point of whether, we're not arguing for a cooling off period. All we're saying is we have two laws here that were considered at the exact same time on the same record, and just as the city considered this, the state considered it. And where the state has dealt with the problem and where the state has come up with a balanced solution with an intent requirement, with an injury requirement, avoiding the meaningless phrase compress the diaphragm, it's appropriate to conclude that the state rule governs and that every municipality doesn't get to prescribe a web of other laws that fail to address, that come up with a different solution on the problem addressed by the state.
Thank you.
Thank you.